Hearing the appeal, Bertino against the Public Prosecution Office, Italy.
Good morning. Mr. Fitzgerald.
Good morning.
Before we commence, can I just raise with you, I think, 3 points. First, I think parties have to bear in mind the issues that were before Mr. Justice Swift and the scope of the appeal that was allowed to him. That's point one. Point two is the panel is concerned about the very late production of notes of argument, A, because of the inconvenience it causes to officials in the court, and B, perhaps more importantly, the risk of unfairness to the opposing party. And the third point is in these cases, the court would find it helpful if the European arrest warrant and any replies to further questions were included in the core bundle, because we are struck by the fact that this important document and its terms have not featured to any great degree in counsel's arguments. So I would invite you to take us early on in your submissions through the European arrest warrant in this case. Thank you.
Yes. Yes, my Lord, I will do so, and I apologise. My Lord, I apologise to the court if the reply was late. It was an attempt, in the light of the respondent's argument, to refine the issues, and I hope that it has done so.
Yes, but the respondent's argument was in quite a long time ago.
Yes, my Lord.
And this is this is producing a reply submission irregularly on the eve of a hearing.
Well, my Lord, I did notify my own friend, but I accept we only served it on her in draft on the Thursday, so we apologise for that. My Lord, could I then just simply summarise the point that we advance? And firstly, the court, I know, has the appearances. We say that it was wrong for Mr. Justice Swift, and before him, obviously, the district judge, to find that the appellant was deliberately absent from his trial in September 2017 because of his alleged failure to notify of the change of domicile when he left Italy in 2015. And it's wrong because at that time he had not been charged or even told he was to be prosecuted. Essentially, our submission under Article 6 is you can't waive a right to be present at trial at a time when you're not facing a trial. And we respectfully submit that the approach adopted by Mr. Justice Swift was wrong, and obviously because he was upholding the decision of the district judge, that was wrong too. The relevant question, that's to say the question under Section 20, subsection 3, should have been decided differently. And in summary, we make three objections. Firstly, it was inconsistent with the true meaning of the word deliberately in Section 20, subsection 3. And the court will see that we've relied on the definition of Canada, in the Canada Square case, of the word deliberate as different from reckless. Secondly, the approach was inconsistent with the requirements of Article 4A, 1 and 2. And thirdly, it was inconsistent with Article 6, which requires a knowing and unequivocal waiver. My Lords, that's our case in brief summary. In our case there's just one matter I should put right or qualify. In our case at 8.6, that's at page 88, we have submitted that we've referred to the fact of no prior history of the criminal justice system. That just requires some qualification. At the time of the hearing, before the public prosecutor, it is accepted that the appellant had 2 convictions for driving matters, driving without a licence, but there is no evidence that this involved formal procedures of the nature of those involved here, i.e. being summoned to a prosecutor's office. I'd also, just to put that right. And then...
So 2 road traffic convictions?
Yes, for driving without a licence, yes. But they didn't involve formal procedures of the natures involved here. I think he was...
no evidence.
Yes, sorry, there is no evidence that they involved those formal procedures, and my instructions are they didn't. The position then, the court has the bundle, the supplementary bundle, which exhibits the Canada Square case, which we say is of assistance, and the short note. My Lords, if I can just then take you, could I just take you to the short chronology which is in the reply, because that may be the best way to take the court through the background facts. That's at A16. And I will come, my Lord, straight away to the EAW at the end of that. So one has at A16, the alleged offence is on the 19th of June 2015.
Sorry, my fault. When you refer to A16, what do you...
This is a supplementary bundle, my Lord.
Right.
It should have A16 at the top. Does my Lord have it?
Yes.
Right. I've got something which starts at A1, A2. So
yes, my Lord. Thank you very much.
Right. Yes, I should also point out that one of our number will be working from paper documents rather than electronic documents. So I'd ask counsel to refer to both the paper and the electronic references in this appeal. Thank you.
Yes. Well, I have a paper, and I think it says A16 at the top too.
No, in this case, you have directed us quite correctly to both the electronic and the paper.
Thank you, Madam. 19th of June 2015 is the alleged offence. And then in his proof of evidence, the appellant states that he went to the police station in Venice province. The respondents don't refer to that. And he was told by the police that they would be in touch if they needed to question him. In his proof of evidence, he also says he then lost his job. 23rd of July, which is
evidence, he also says that he was interviewed.
Yes, absolutely, yes, he does. Yes. On the 23rd of July 2015, he signs a document at the Spadafora police station electing domicile for purpose of the service of process. And that document the court has in the appendix at A205, and I can take the court to that at A205. You can see that what one has there is a record of declaration of domicile for service of process. One has reference to Salvatore Bertino, born in Messina, etc., and then the reference to following a notitia criminis, so that's notice of a crime, and then the key bit that we rely on is that the person specified above is invited to declare or elect domicile in Italy under Article 161 of the Code of Criminal Procedure, and he is warned that as he is being investigated, he is under an obligation to notify any change of his declared or elected domicile. And so a notitia criminis, we understand, is an information that a crime has allegedly been committed. But it's different from being arrested or charged or a later decision to prosecute. That comes at a later stage after the investigation. So that obviously is important, my lords, because we say at that stage he is not being prosecuted, he is being investigated. Now,
I don't think that's in dispute, is it?
No. I think it's really a question of what. I think my learned friend may take a point about what the meaning of investigated is, but
yes.
But I'm right. So he states in cross-examination, this is in autumn of 2015, what he says about that is that he told the police before I left that he was going abroad, This was in order to leave full responsibility with my wife. And when he was being cross-examined, this is at page 251 again, he said that he gave the police his address.
Do you mean page 251 or 205?
My Lord, it's page 251, you see the notes of cross-examination. My Lord, does my Lord have it?
Yeah.
Page 251, just at the bottom. So one sees SH, my Lord friend, who lives at that address, the one I gave to the police myself and a friend of mine. Which address are we talking about? 239 Fredingham Road, Scunthorpe. I'm talking about the Italian address. And at this address, is anyone still living at the address? No, but they have my English address, the same address where I'm tagged. So he refers a bit higher up to, I went to the police station and signed the paper saying I was going to the UK, which is why I was giving responsibility to my wife, but it was not in respect of this criminal accusation. If I go to the police and I change my address, whether it is for one purpose or another, they had my address. So he's saying that he gave his address in Scunthorpe. Now, then he came to the UK to get work, and that's in the proof of evidence at page 243, at paragraph 4, and that is 5 months after the alleged offending and 4 months after the encounter at the Spada Fora police station. The proximity may be important because the judge says no coincidence that he left, but if there's an alternative explanation, which as a result of this accusation, he'd lost his job and he was seeking work in the UK, then that point loses some of its force.
So that was page 245, did you tell us?
243, my Lord.
243, thank you.
Yes, my Lord, 243.
Thank you.
Then over the page, nearly 2 years later, the decision to prosecute is taken. I know the court has that. That's a point we've highlighted throughout the pleadings. But on the same day, the first writ of summons is issued. And it's in that writ of summons, which the court has at page 216, that one has the warning, with warning to the accused that non-attendance without lawful impediment shall lead to judgment in absentia. So that's the first time that one has that warning given.
So the date of this again?
The date of this is the 8th of June, 2017. So that's the, and also it's there in the chronology.
So whereabouts is the warning?
It's at page, no, it's 216. It's page 235. I'm so sorry, my lords. Yes, the warning. Yes. Yes, I see. Absolutely. Thank you very much. Yes,
so the writ is 235.
Yes, and then with warning to the accused under the order that non-attendance without lawful impediment shall lead to judgment in absentia. So if that is a requirement, which we submit it is.
So let's look at this document. The order, the summons before the judge on a certain date, and then the warning in the next paragraph. Is that what you're saying?
The warning's at the top.
Yes.
Yes.
Yes. And in fact, that's for trial on the 28th.
In the next paragraph, I noted, when preparing for this, that it says requests, and the text seems to come to an abrupt halt. In the last line, with warning that in the event of failure to communicate any, and then it stops.
Yes, ma'am. Oh, yes, I see. Yes, yeah, under the word my lord, yes.
Be that
Yes,
as
it
may.
does. Well,
But you say there's the clear warning,
yes.
and this document was served on whom?
I think it was served on his. It was served on the lawyer who had been appointed to represent him, I think. It certainly wasn't served on him.
No.
But and then one sees that there's reference to various attempts to trace the appellant from the 2nd of August 2016 until 16th of December 2019. We've set those out against the 2nd of August 2016, but it's from then onwards. But they are unsuccessful. And then on 28th of September 2016, the hearing commences in the appellant's absence, and one sees that in the judgment at 216, that one sees decree of public order that Bertino be brought to trial to answer the criminal during this hearing, which took place in the absence of the defendant. That's halfway down, does my lord see under in fact and in law. So the hearing, which took place in the absence of the defendant after the civil plaintiff had been constituted, postponement was ordered at the hearing, and then one sees the reference to the various hearings, and then he is.
Yes, so yes, it talks about the impending investigation continued, just below. The fourth paragraph down in fact and in law. So and then the investigation was declared closed.
Yes, closed, exactly, my lord, yes. And then he's convicted on the 16th of April 2018. We have that at 221. Where the date is 16th of April, and the...
What page number?
It's page 221 at the top, my lord.
Thank you very much.
But it seems that the investigation is treated as continuing. This is still on page 216.
Yes.
Continuing till the moment of conviction.
My lord, I accept that, but it's clear that this is a new phase because it's a trial phase, but I accept that they use the expression the investigation closed.
Yes, but it's just we've got to be slightly careful compartmentalising between investigation, prosecution and trial.
Well, my lord, what we respectfully submit is that there is a clear point at which a decision is taken in June 2017, and that is a new phase of the proceedings. And it's on that day that the writ is issued with the warning. So that whether you say that the whole thing is an investigation, there's no doubt that there's a new phase, which is the prosecution, which begins on the 8th of June 2017. Yes. Yes. Well, yes. It's at page. My learned friend just drawn my attention to how it's described by the respondents at page 111, paragraph 30. In due course, the trial described throughout the judgment as an investigation took place. The judge regarded his absence as the result of his free choice, and so that they refer to that fact.
So the statement of facts of issue says that paragraph 6, Roman numeral 2, when was the decision to prosecute the appellant taken? And the response is the prosecution started on the 8th of June 2017.
Yes, yes, my lord. We do say that there is no doubt that there was a difference at that stage. A decision to prosecute was taken, and then, my lord, the sentence just going from there, the police then established the appellant's contact details in the UK, and that's at page 226. And one sees that record on successful searches, and then one sees that they did locate him and in the UK, although of course he says, well, I told them where I was right from the start. But then the sentence is activated on the 27th of January 2020. So originally it's a sentence of 1 year's imprisonment, which is suspended on condition he pay compensation within 6 months. That's at page 221. And then the sentence is activated. And, my lords, if you come to the EAW then, that is dated the 6th of February 2020. And we obviously apologise that that was not in the core bundle. I accept your lordship's reproof on that. But at page 191 of the appendix, one sees the EAW, and from our point of view, the most important point is that there are no, the box D dealing with the issues of not appearing at trial. One sees page 192D. Please indicate if the person appeared in person at the trial resulting in the decision. No, the person did not appear in person at the trial. No, he was not present at the trial. He was defended by a lawyer assigned to him by the state. So not his lawyer, but an appointed lawyer. By judgment, he was granted suspension of the sentence subject to obligation to pay compensation. Subsequently, it was revoked by order issued by the Court of Pordenone due to non-compliance. And if the court looks down, then one has free, and if you've ticked the box under point 2, please confirm the existence of one of the following. Free 1A, the person was summoned in person and thereby informed of the scheduled date and place of trial, and was informed that a decision may be handed down if he does not appear for the trial. Or free 1B, the person was not summoned in person but by other means actually received official information of the scheduled date and place of the trial, which resulted in the decision in such a manner that it was unequivocally established he was aware. Anyway, there's no tick. And being aware of the scheduled trial appointed a counsellor, no tick. And again at 3.3, no tick. Now, the importance of that is, in the case of Cretu, my Lord Burnett, of course, said that if you've ticked the boxes, that is conclusive, and you can't get behind it. Of course, if you haven't tick the box, then the position is that set out in Striecki, which we have at tab 34 of the bundle at page 975.
So just before we leave the
yes,
the arrest warrant, is this text a standardised text laid down by the EU instrument?
Yes, my lord. You can actually see it appended to the 2009 directive, my lord. This is the form that they.
Do you mean decision?
Yeah, I'm sorry. Yes, 2009 framework decision. Yes. I can show your lordship that if that would assist at this stage.
Just a bundle reference would be.
Yes. Yes. Okay. It's at tab 8. Page 438. I'm very grateful.
Page 438.
438, yes, that's it. 438, when you see there that they actually give the form and it's set out.
Is it identical? Because I didn't think that this form was identical to the one used in Cretu. But that isn't may.
No.
I can follow that through.
Yes, my lord. So one sees that page 438 to 439, the form which we actually have reproduced at 192 to 193. And it may be of some importance that that form was, and that's the point we make respectfully in the reply, that the form reflects what's required by Article 41A 1 and 2.
Yes, you're going to take us to what was the situation if the box was not ticked.
Oh, yes, my lord, I'm grateful, yes.
Before we go to the case, can you summarise what is the effect of not ticking the box?
It means that the court then decides for itself whether the requirements have been met. Were it ticked, the judgment in Cretu says you can't go behind it. If it's not ticked, then the court must decide for itself.
And your reference for that submission
Is the case of Striecki, my lord, and that's at page 9, tab 34, 975. Yes, so it's my lord. So Striecki. I hope that's the right way of pronouncing it, but it's certainly, it might be Striecki, but
Well, I'm not in a position to contradict you.
Lord, with my Polish origins, I'm sure I would get it right. But if one looks at 975 at page 50, one sees Roman. This is a series of principles laid down by Lord Justice Higginbotham in the case of Striecki, and one sees that he says there, if Roman 4, if the statement in the EAW is ambiguous or confused, then it is open to the court considering the request to conduct its own assessment of whether the requested person was summoned in person or by other means actually received official information of the scheduled date and place of that trial on the evidence before it, the burden being borne by the requesting state to the criminal standard. And then summoned in person means person, yes, and so one sees that, and I think he says that our fortiori, yes, our fortiori if there's no statement at all, yes. So we are in the our fortiori position. So it is for the court then to decide it, and we don't dispute that the court did seek to decide it. We just respectfully submit they did it wrongly. My lords, if I can then take the court, that's the background chronology. If I can take you now to the case and just take you briefly through the key propositions. The court, I think, has our points at 1.2 because I've made them in the course of the chronology, but that's at page 64 of the case. So the first 1.21, the first contact that Appellant had with the police was on 23rd of July. That's on their account, although he says he actually was interviewed in Venice, or in the Venice region, straight after the alleged offence. But rather the 23rd, and then if we look down, its investigations are being conducted, and it required him to inform the judicial authority of any change in address. That's what he did. His evidence was that he informed the Spadafora police as a judicial police officer that he was moving to the UK, and you've seen what he said in his cross-examination, that he actually said that he was gave the address, and the respondent's position that the appellant did not inform the police of his change of address in relation to this specific allegation, which was what was put to him in cross-examination, we say is entirely hollow. They were the same judicial police officers who knew or ought to have known that the appellant was in the UK, and it was futile to send summons to an address which the police knew he did not reside. And then just going over, the court has the fact that no charge, prosecution or trial had started is underlined by the following facts. The respondent's evidence that the appellant was never arrested or questioned in connection with the offence. The respondent's evidence the decision to prosecute was not taken until 8th of June 2017, 2 years later, and there is nothing in the respondent's various supplementary information to suggest that the appellant had been charged or otherwise informed of the right to legal assistance. He wasn't represented at the, I'm going to call it the encounter in 23rd of July 2015. So and then finally, over the page, at page 66, there's nothing in the 23rd of July order informing the appellant that he may be tried in his absence. Indeed, the first time such a warning appears is in the writ of summons, which the court has seen. So in those circumstances, we respectfully submit the Judge Ikram's finding the appellant had deliberately absented himself is insupportable, and furthermore that Mr. Justice Swift's conclusion, this is at paragraph 36, that the appellant could reasonably have foreseen that a trial may go ahead in his absence was manifestly unjustified. Could I invite the court respectfully to cross out the remainder? We're not pursuing the point about
What do you ask us to cross out, sorry?
Sorry, and was arrived at in a manner inconsistent with root.
Where's this?
My Lord, if you look at 1.3, we say it was manifestly unjustified at page 66. We don't pursue the point that he arrived at it in a manner inconsistent with principles of fairness, because we accept the point that this is about an inference. However, we do say there was unfairness at the earlier stage. Now, my Lord, I have to confront the issue, and your Lordship's put it to me right at the start. Why are we arguing about Judge Ikram? The answer is because it's fundamental to the decision of at paragraph 36 of Mr. Justice Swift. And my Lord, sometimes light only dawns just on the eve of the hearing. But can I just put it this way? Because in our respectful submission, it is a fundamental point. If you look at paragraph 36 in the core bundle of the judgment of Mr. Justice Swift, yes. Well, actually, it's in the appendix. It may be simpler to go to the appendix. You've got the judgment in the appendix at page 154, and you've got paragraph 36 at page 175, where he says, this is in question, that there'd been no information that he could be tried in absence if he failed to appear. And at paragraph 36, Mr. Justice Swift says, the judge did not in terms state that it would have been reasonably foreseeable to Mr. Bertino that if he acted as he did, i.e. intentionally, to avoid being served with information about his trial, he would be dealt with in his absence. However, given the conclusions of fact, both primary and secondary, that the judge did reach, it is plainly correct to draw the inference too. So he relies on the findings, both primary and secondary. On this appeal, and this is the important point, the question for me is whether the judge should have decided the Section 20 question differently. I am satisfied that the answer to the question is no. The judge reached the correct conclusion on the application of Section 20 to the facts of this case. So, in the end, all that you have jurisdiction to do, and this is very clear in my Lord Burnett's judgment in Love, is to say, was the decision reached by the district judge right or wrong? Now, he decides that the decision was right, not wrong. And under the appellate provisions that govern this, Section 27(3), the question that has to be asked is, should that issue have been decided differently? And he decides quite clearly there, it shouldn't have been decided differently, i.e. he adopts the reasoning of the District Judge Ikram. You cannot atomise in the way this was atomised into Ground 1A, Ground 1B, Ground 1C. The question which Mr. Justice Swift correctly asked himself at the end is, was that decision right or wrong?
Well, so you're saying you're entitled to argue Ground 1A?
Yeah, my Lord, yes, because
in the face of the fact that Ground 1A was not before Mr. Justice Swift.
Well, it is in the sense that he says he actually effectively decides that he got it right. He says, in the light of the decisions primary and secondary. Well, my Lord.
But also,
yes,
Mr. Fitzgerald, you put to us,
yes,
as an agreed fact, what the appellant says on cross-examination, but don't you have to face up to the fact that the district judge did not accept Mr. Bertino's oral evidence?
Well, my Lord, if we look at what he actually decided, what he says, and this is at page. If we go over to the next part, section 1. Tab 4, page 180. Yeah. So, and it's all about the oral evidence as a signature on the above document at paragraph 4. Paragraph 5, the RP states that he left Italy and came to the UK on the 4th of November, leaving his wife and children at the said address. I've considered the case of Podlas. It makes clear that JA bear the burden to prove deliberate absence from the trial process beyond reasonable doubt. And then it says the trial process must have been initiated and the absence must be deliberate. Well, that's actually wrong. It's the trial that must be initiated, and it's an event, not a process, and that's what Cretu decides. So in citing that bit of Podlas, which was overruled effectively in Cretu, he misdirects himself in law. He says, I do not accept the RP's oral evidence. Well, what is he talking about there? He is rather vague as to whether he signed the said document. So it's solely about his evidence about whether he was aware of the document he signed. It's not about his other evidence.
No, but he's made no findings of fact of acceptance of it, of evidence that you're putting to us and telling us to accept as agreed fact.
My Lord, I'm not inviting you to... Our complaint is that it was unfair for him to reach the conclusion, if I can put it at paragraph 10, and that's at page 181. I find it no coincidence that the RP left his address without notifying a forwarding address and emigrated to the UK within months of being released from the police station. He did so in full knowledge the police wanted his address, so they knew where court papers could be served. I find that he left the country so that he could be not be located, to be served with papers, future dates for his trial. Now, our respectful submission is, if you're going to make that finding, you've got to deal with the fact that in his evidence he'd expressly said that when he left the country, he left to get work, and that he did say, I'm leaving, and he did give them an address. He'd have to say, I don't accept that evidence.
Well, in sentence 1, he's saying precisely that.
He said it. Paragraph 7, I don't accept the RP's oral evidence.
But
Paragraph 10, he draws the conclusion from not accepting.
well, my Lord, it's the evidence.
We're not here to retry the facts.
Well, no, my Lord, but with respect, it is open for us to respectfully submit that in endorsing the judgment and relying on those findings, Mr. Justice Swift got it wrong. Because the bit about I do not accept the RP's oral evidence is clearly in relation to what he had said about his signature on the above document. You can see the RP above that confirmed in oral evidence that it could be his signature on the above document. He either suggested that he did. That's what he's not accepting. That's the oral evidence is a very specific oral evidence that he's referred to at paragraph 4 and that he continues to analyse at the rest of paragraph 7. So, my Lord, our respectful submission is that he simply didn't have the warrant without addressing the evidence. I told them that I was going to the UK. That's the first thing. And I told them where I was going in the UK. To say he did it in full knowledge. And then I find he left the country so that he could not be located to be served with papers, future dates for his trial. Well, your Lordships have our general point, which is that it was too early a stage for that finding to be made.
Well, yes, but there are legal points to be made, but I wonder whether the scope of this appeal extends to making alternative findings of fact.
Well, my Lord, it's just there's we respectfully submit there's simply a lacuna on this issue. He makes a finding of fact. I don't accept his evidence about not knowing what he was signing, which is referred to at paragraph 4. He makes no finding. He doesn't even recite the evidence. He said that when he left the country, he told the police where he was going, and he gave the address. He just doesn't address that. But it's fundamentally unfair to make a finding on that without addressing the evidence. And so when he says, I find that he left the country so that he could not be located, well, what does he say about the specific evidence, which was not challenging? In cross-examination, it's just put to him, well, you may have told them, but that was not in relation to this matter. It was in relation to not wanting to be abandoned. So, my Lord...
This is all ground 1A, isn't it?
Well, my Lord, yes, but if in fact, my Lord, I apologise for pressing this, but in our respectful submission is fundamental. If in fact what you get leave on is the relevant question, and the relevant question is, did he deliberately absent himself from trial? Because that's the issue, that the structure of the appellate scheme requires to be addressed, then that's the issue on which the adverse finding is made. He was deliberately absent, and we see that at paragraph 36. That's exactly what Mr. Justice Swift does. He says, I find, I'm satisfied the answer to the question is no, i.e. the judge should have decided the question differently. And our respectful submission is that this court has jurisdiction to say the answer to that question, that relevant question, should have been it should have been decided differently. And my Lord, one can't really address that. I mean, there are other issues about you can. Gallagher has establishes you can travel beyond the certified question, but I accept your Lordship's point. The question is, what is the status of the refusal on one part of 1A, 1B, 1C? And we say what in fact the judge did in granting permission was to grant permission to challenge the relevant question, the answer to 20 subsection 3. My Lord, when you're given leave, in our respectful submission, you're given leave on the relevant question. So, for example, we couldn't argue passage of time, which is another relevant question. But the relevant question that you're given leave on is, was it right to decide that he was deliberately absent?
How does it fit within the 2 certified questions that we have from the judge and or 4 grounds of appeal?
Well,
and then the issues that have been agreed for the appeal.
Well, my Lord, firstly, as your Lordship knows, we've cited the case of Gallagher, which says that the court is not confined to the certified question. It can look more broadly. And we've cited that at top of page 67, Gallagher. So that's the ground of the appeal on which we have leave. We say requires consideration of Judge Ikram's approach.
Sorry, where did you say you cited Gallagher?
Sorry?
You said you cited Gallagher.
Yeah, we've cited it at page 67 at the top, and what Gallagher decides is that you can go beyond the certified point. And indeed, they did it in that case, and that's cited with.
Just out of interest, do you need permission of the Supreme Court to do that?
Well, in the sense that
one might have thought so.
Yes, my Lord.
You haven't even asked for our permission to do this.
Well, my Lord, we effectively do it at Roman 1 because we say Judge Ikram's phone was deliberately absent. He wants to be unsafe. The Supreme Court has the power, and that's in our case. Sorry, can I just?
You've got 4 grounds of appeal, I think.
Well, we have, because we had it as a preliminary point. It's at Roman, it's part 4, finding on article was manifestly unjustified. That's at paragraph 4. Yes, and can I just show at the SFI, can I just show the court in the SFI at pages 61 to 62? So this is at the bottom, issues in this appeal. The issue is whether the lower courts were correct to conclude that the appellant deliberately absented himself from trial for the purpose of section 20, subsection 3. In answering this question, the parties agree that the following additional issues fall for determination. Did the lower courts correctly interpret section 23 in the light of article 4A1A, relevant ECHR principles and EU provisions? If the reasonably foreseeable test is operative, is that an objective, subjective, or a mixed?
Sorry, where are you reading from?
It's page 61 and page 62.
61, 62 in the statement of facts and issues.
Yes.
Sorry, yeah.
So the issue is whether the lower courts were correct to conclude that the appellant deliberately absented himself from trial for the purposes of section 20, subsection 3. In answering this question, the parties agree that the following additional issues fall for determination. Did the lower courts, but courts, plural, correctly interpret section 23 in the light of Article 4A1, 4A1A, relevant ECHR principles and EU provisions? If the reasonably foreseeable test is operative, is that an objective, subjective, or a mixed objective, subjective test? How does the reasonably foreseeable test operate in the light of the burden and standard of proof? So it is the issues formulated and agreed are, in our respect for submission, wide enough to cover the point.
But I mean, I have to say I read those as being issues of law, not
As did
going
I.
back over the facts and trying to invite us to make different findings of fact, which anyway would be inappropriate.
Well, my lord, the question is, what is the finding of fact that is binding? And we say the finding of fact that's binding is that his oral evidence as to what he read his oral evidence as to his knowledge and signature of the order was not accepted. That's the point. My lord, there is.
I thought did he not deny knowledge of the order, and that's the evidence.
Yes.
So in other words, there's a positive finding. He signed and knew about the 2015 order.
Yes.
I may have been naive, but I had rather thought that this appeal was, given that that's his state of knowledge, what was in the 2015 order, is that a sufficient basis for the courts to find that he had, whatever the relevant expression is, waived his right to appear at the trial or participate in the trial?
Yes. Well, my lord.
Well, that seems like quite a crisp issue of law arising on established facts.
My lord, we're content to argue on that basis. The only problem is the finding at paragraph 10, the meaning of that. I find that he left the country so that he could not be located to be served with papers, future dates of his trial. And that we respectfully submit was not in fact justified. But my lord...
So are you saying that it's critical to your case that we reject paragraph 10? In other words, could we accept paragraph 10 and still decide the legal questions in your favour?
Well, my lord, it's a difficult issue, but yes, if we're right, and this is our prematurity point, if we're right that what you do before you're prosecuted, you're actually charged and prosecuted, is the starting point, then the fact that of that factual finding would not stand in the way of us succeeding.
At one level, your case is simply that he was told that he was under investigation. He didn't know whether a prosecution would proceed. He didn't know whether a trial would proceed.
Yes, my lord.
And you'll be saying that his knowledge in 2015 does not come up to what the case law would treat as a deliberate absenting yourself from trial.
I'm obliged, my lord. And I mean, I think the court has our submission that finding, so far as it's an intentional one, was not consistent with the evidence, which the specific evidence on that issue, which was neither addressed nor rejected.
Paragraph 10, the finding in paragraph 10 isn't finding that he knew that a trial process was going on. So I would have thought in answer to my Lord Borough's question, you can reply, no, it's not critical to my case that this court overturns the facts found in paragraph 10.
No, no.
If that's so, I mean, I come back to what I was seeking to press you on. Right. Is it even appropriate for us to be invited to go behind paragraph 10 on this appeal? Well, apart from myself, see that it is.
Well, my lord, if you have our submission, my lord, I say you do have jurisdiction to do so, and because it's inextricably bound up with the finding of Mr. Justice Swift, you could do so if within the Gallagher test. But, my Lord, let me not waste any more time. Let me try to deal with the point, assuming that finding in any event.
Mr. Fitzgerald, just before you move on, paragraph 10 we've looked at, but in paragraph 8 of the judgment of the district judge, he says, I find the requested person was aware of, at that moment, that criminal proceedings were a possibility.
Yes.
And so, I mean, presumably you would say that the fairly stark language in paragraph 10 needs to be read in the light of the judge's acceptance that they were simply a possibility.
Well, my Lord, I'm very grateful. That perhaps is the way round. And that is our case. That's our primary remoteness point is, if all you can say at the stage that he leaves Italy in November 2015, that he knew that criminal proceedings were a possibility, then that's not enough. But it is just because left the country so that he could not be located to be served with papers, future dates for his trial. I suppose, or if one wrote in there possible future dates for his trial, that might solve the problem. And that's why we felt it incumbent to challenge that finding. My Lords, my Lords, if I can go then straight on to part 6 of the case. We there say that there is a requirement to expressly inform that a trial may go ahead in absence, and that's basing ourselves on Article 4A1A. The person must be informed of the scheduled date and place of trial and be informed that a decision may be handed down if he or she does not appear for the trial. And so that's the, secondly, while the meaning of 4A1A2 has not been litigated before the CJEU, the case law of the CJEU strongly suggests that they are cumulative requirements. The person convicted in absentia was aware in due time of the scheduled trial and was informed that a decision could be handed down if he did not appear for trial. And then we say that that is supported at 82 by the EU directive on the strengthening of aspects of the presumption of innocence. Article 8 is the operative article, and we've set it out there. And then recital 36 of there. So the suspect, so member states may provide that a trial which can result.
I'm sorry, Mr. Fitzgerald, which paragraph?
Paragraph 6.4, my Lord.
6.4.
Sorry, my Lord, at page 82.
Yep.
Does the court have it? Member states may provide that a trial which can result in a decision on the guilt or innocence of a suspect or accused person can be held in his or her absence, provided that the suspect or accused person has been informed in due time of the trial and of the consequences of non-appearance, and the suspect or accused person, having been informed of the trial, is represented by a mandated lawyer. And then recital 36. Under certain, it should be possible for a decision on the guilt or innocence of a suspect or accused person to be handed down even if the person concerned is not present at trial. This might be the case where the suspect or accused person has been informed in due time of the trial and of the consequences of non-appearance. And then going down, informing the suspect or accused person of the consequence of non-appearance should in particular be understood to mean informing that person that a decision might be handed down if he or she does not appear at the trial. And our fourth point in reliance on Strzeżewski is the proposition that a failure to inform a person that he may be tried in absentia is a distinct reason the person cannot be deliberately absent from trial. As Justice Higginbottom cited at paragraph 48 the relevant provisions of 4A1A. And Mr. Justice Higginbottom then summarised at paragraph 50 a series of propositions as to the interpretation of Article 4A1A1. And Mr. Justice Higginbottom found, and I think I've just taken you to other parts of that judgment, but you've got the citation here, that he made a separate finding about the fact that the appellant was, there's no evidence at all that the appellant was informed that a decision may be handed down if he did not appear for the trial. And so the criterion in 4A1A2 was not met. Therefore, on the evidence, the judicial authority has failed to satisfy me. The requisite criteria for notification set out in 4A1A were met. So, my lords, if I can just go, that is the point. And if I can just go back just briefly to our legislative analysis, we've dealt with the legislative framework back at page 68. So the court has the Extradition Act 2003, and the words are deliberately absents himself from trial, and we've set it out at page 69. If the judge decides that question negative, he must decide whether the person deliberately absented himself from his trial. We've dealt with the meaning of the word deliberate in the reply, and we've cited there in the reply the new case, which it establishes the Canada Square case, which establishes that deliberate does not mean reckless. Can I just give the court the references? It's at paragraph 1 of the judgment setting out the question at A21 of the bundle. It's at paragraph 112 where the clear statement is made. As a matter of the ordinary use of language, the adjectives...
What page is that, sorry?
Page A64, my lord. As a matter of the ordinary use of language, the adjectives deliberate and reckless have different meanings. As one would expect, their ordinary meanings are reflected in dictionary definitions. For example, the Concise Oxford Dictionary defines deliberate as meaning done consciously and intentionally, and reckless as meaning without thought or care for the consequences of an action. And then finally, if one goes on to paragraph 153 at A77, for all these reasons, the reasoning of the Court of Appeal in relation to section 32(2) cannot be accepted. Deliberate in section 32(2) does not include reckless, nor does it include awareness that the defendant is exposed to a claim. As Lord Scott said in Cave, the words deliberate commission of a breach of duty are clear words of English. They mean, as he added in paragraph, that the defendant knows he is committing a breach of the duty. My lords, in essence, what we're saying is you can't deliberately absent yourself from trial because you breached some duty to notify of change of address before you even knew you were being prosecuted, whereas my lord helpfully put to me, all you know is criminal proceedings may be a possibility. And the court has that, so that's the terms of section 20, subsection 3.
Just before you go on, but you're putting the case more at a higher level than that, aren't you? Because as I understand your first ground, you would need to inform the defendant of the date of trial, or the trial's going ahead, and that defendant should be informed that it may go ahead in his or her absence. So I mean, how exactly are you putting it?
Right, my lord, can I attempt to put it in this way? What we say is you must be informed of the date and time of trial. That is only subject to one exception, where you deliberately, whilst on notice that you are to be put on trial, evade service of the date of trial. So deliberate evasion, and is the test. And my lord, can I just, I think I can show you very shortly the authorities that we say that support that the timing is, first of all, once you've been prosecuted or charged. That's the first thing, and that you must be deliberately seeking to evade service of that information. Now,
So just to be quite clear, yes, you have to know you are prosecuted.
Yes.
You're being prosecuted or charged.
Yes.
But you're deliberately evading the intimation of the date of trial.
Yes.
And the fact that the trial will proceed in absence.
Well, my lord, that we say you should be informed of when they tell you you're going to be prosecuted. And it's like in England when you first appear, when you appear at the pre-trial hearing, you are expressly warned under the criminal procedure rules. You must turn up for trial, and if you don't turn up for trial, you'll be tried in absentia.
But say that isn't there. Say that wasn't done.
Then we say that would be fatal under Article 4A1.
So you do have to be told that you can be, that a trial can go ahead in your absence.
Yes, my lord. Yes.
And you must receive that information.
My lord, that is our submission. But that's our first submission, my lord. But in any event, you would have to be. There would have to be a finding in order to evade that, at the very least, that you were deliberately seeking to evade notification of your date and time of trial and of that information. Can I just try to flesh this out by some cases?
Sorry, I didn't understand the last part. I thought your submission was that once you know that you are being prosecuted and charged,
yes,
you will at that point normally be told
yes,
that a trial can go ahead in your absence.
Yes, yes,
and
yes.
that if that is missing,
yes,
that's immediately fatal.
Well, that is our first submission. That's the Article 4A1(2) should be read into.
Right.
So that is our first submission. But, my lord, we do have a fallback position, which is if it's only if there's a finding that you're deliberately trying to avoid service of the information. But, my lord, can I just explain?
Sorry, of what information?
Okay.
So I was understanding the main submission that you're making to be that you do need to be informed that you could be tried in your absence.
Yes, that is our first submission.
And so that needs to be brought to your mind. Yeah. And thereafter, if you deliberately evade service of details of when the trial is, that's not going to be.
My lord, that is our primary submission. That is our primary.
And speaking for myself, I could see that one could say then that you have, if you have been told that you can be tried in your absence, and then you make yourself scarce.
Yes.
That you are deliberately.
Yes.
Avoiding trial or whatever it is.
Yes.
You have deliberately absented yourself.
Yes. Well, my lord, that is our primary submission, and that is really spelt out.
So now where I lost the thread is what alternatives?
Well, maybe the alternative was that at the very least you have to have been notified that you are being prosecuted.
Yes, so the fallback is that if you've been notified that you're to be prosecuted and you deliberately avoid service of any information, whether it be the date of the trial or whether it be that the trial would proceed in absentia, that would be
my lord.
that might meet the criterion, but that's very much your fallback position.
My lord, that is right. The prematurity point, if we
that's the prematurity argument. Yes.
So just let me understand it. If an individual has been notified of a date and trial, but then tries to evade all information, and some of that information is going to be that you can be tried in your absence, you say that is not sufficient. Is that right?
My lord, that's our first submission, because you should have been told at the time. This is your date, and this is the date of trial, and if you don't turn up, you can be tried in your absence.
And is there a discretion still to compel the surrender of an individual, even if the 4A1 and 2 aren't satisfied?
Well, that's the point that's raised in Prosecutor, and can I put it this way? We say you should, following the Cretu case, interpret section 20, subsection 3 in conformity with 4A1 and 2, 4A1A 1 and 2. We say that if there is a discretion to say, well, they're only optional, and in the absence...
I'm so sorry. When you say, Cretu says interprets section 20, subsection 3 in conformity with 4A 1 and 2, does that mean, in answer to my Lord's question, the answer would be there is no discretion to compel if those subparagraphs have not been satisfied?
My Lord, yes, that is our first submission.
That was open in Cretu because that was the interpretation of scheduled date and place of trial.
Yes.
Which was interpreted in accordance with Article 6.
Yes. Well, my Lord, I think it may help if I just take you first to the article itself and just show you how we say we interpret. So if I can take the court firstly to the relevant articles. One has Article 4A1 at page 435 onwards. You have the decision, and I just will take you to Article 4A1. You have.
Well, I'm so sorry, just before you get there, aren't the recitals of some significance as to how...
Yes, my Lord.
I mean, in particular, recital 1 seems to, well, does rehearse the importance of Article 6 of the ECHR.
Yes, I accept that, my Lord, and I should take you, in those circumstances, I should take you to 4, it's therefore necessary to provide clear and common grounds for non-recognition. This framework decision is aimed at refining the definition of such common grounds, allowing the executed to execute. And then of relevance, I accept, is at 7, the recognition and execution of a decision rendered following a trial did not appear, in which the person concerned did not appear in person, should not be refused if either he or she was summoned in person and thereby informed of the scheduled date and place of the trial, which resulted in the decision, or if he or she actually received by other means official information of the scheduled date and place of that trial in such a manner that it was unequivocally established that he or she was aware of the scheduled trial. So that's the information. And then going on from there, paragraph 8 of recital 8, the right to a fair trial of an accused person is guaranteed by the Convention for the Protection of Rights and Fundamental Freedoms. This right includes the right of the person concerned to appear in person at the trial. In order to exercise this right, the person concerned needs to be aware of the scheduled trial. Under this framework decision, the person's awareness of the trial should be ensured by each member state in accordance with its national law. So this is about Article 6. In accordance with the case law of the European Court of Human Rights, when considering whether the way in which the information is provided is sufficient to ensure the person's awareness of the trial, particular attention could, where appropriate, also be paid to the diligence exercised by the person concerned in order to receive information addressed to him or her. Now, the point which was made below, and which we make again, is what is it that the diligence refers to? It's diligence exercised by the person in order to receive information. What is the information? The information is that which is described at recital 7, thereby informed of the scheduled date and place of the trial. And so you must, so it's possible to say this person, by his conduct, we would say by deliberate conduct seeking to evade, has made it impossible to provide them with the information of the scheduled date and trial, and therefore they can't rely on the fact that they weren't informed of the scheduled date and trial. But there's no suggestion that you can dispense with the requirement that the person be told that if they don't turn up for trial, they could be tried in their absence. So can you just show me for? Yes. So yes, one sees under. Yes. So if I can just take you to 437, the following article shall be inserted, and then one sees Article 4A. May also refuse to execute the executing judicial may also refuse to execute the European arrest warrant issued for the purpose of execution of a custodial sentence if the person did not appear in person at the trial resulting in the decision, unless the European arrest warrant states that the person, in accordance with further procedural requirements in due time, one, was summoned in person thereby informed of the schedule, date and place of the trial. So that's being informed of the date and place of trial. And B, and it's important that it's an and, so it's a separate requirement, was informed of the decision may be handed down if he or she does not appear for the trial. So we say those are two cumulative requirements. Now, and we say that if you look at recital 8, the question of due diligence there relates to being informed of the date and place of trial, not to dispensing with the requirement that the person be told that if you don't turn up, you'll be tried in your absence. And I think it may be of assistance to the court if at this stage I simply take the court through some of the key cases that we rely on, both for the proposition that the duty to inform scheduled date and trial it must be complied with, but that you can rely on absence or default before the person has been prosecuted. And the first of those cases is Bitchioch at tab 27, page 867, which helpfully summarises the previous law. So if the court goes to Bitchioch, so that's at tab 27, Mr. Justice Mitting and he's interpreting section 20 subsection 3, cites the case of Bletter, which is in relation to the Part 2 equivalent at paragraph 9, page 867. The word trial was adopted by Parliament in the context of the presence of Article 6. Article 6 confers the right to a fair trial, and the word trial would not have been used by Parliament if a wider view of absence had been intended. And then one can see D, Parliament could have used an expression such as deliberately absenting himself from legal process, which could, on appropriate findings of fact, including leaving a jurisdiction to avoid arrest. Parliament has not done so. Subsection cannot be construed as if it had. And there's similar provisions in statements in Atkinson at paragraph 10. And then if I can just take you to paragraph 14, after citing Article 4A, paragraph 14, page 871, the framework decision of 2009 accordingly made it clear that as a precondition of a requirement for the executing judicial authority to extradite a person, that person must be notified in due time of the scheduled date and place of the trial and told that if he does not attend, a decision may be handed down unless the person has, having been made aware of the trial, given a mandate to a legal counsellor, or having been served with the decision, is given a right to have the issue reopened at a retrial or appeal on the merits, and either expressly states that he does not contest the decision or did not request a retrial or appeal within the applicable time. And then he says the framework decision fits in far more closely with the reasoning we've letter. And then can I just take you finally?
Is 14, does paragraph 14 reflect the structure of 4A, which seems to say that you may refuse to execute the arrest warrant unless, and then those conditions?
Yes.
So what it seems to be saying is if those conditions are met, you cannot refuse extradition. But if those conditions aren't met, what then?
Yes. Well, then, my Lord, we have two submissions in relation to that. If I can put it. Firstly, that we rely on my Lord Burnett's judgment in Cretu, saying that a conforming interpretation must be adopted, so one that gives effect to the requirements of 4A1 and 2. And secondly...
Sorry, that's the bit I don't understand. I can see a conforming interpretation means that if the conditions are met, there is no discretion. You have to send the person to the requesting state. But the question was, suppose the conditions are not met.
Yes.
What then?
My Lord,
this article doesn't seem to tell you that. Other than say you in fact then can refuse to execute the arrest.
Yes. Well, my Lord, that certainly, if one goes down, if one finds that Section 20, subsection 3, is really just giving effect to Article 6, then the residual question would be: would it be inconsistent with the Article 6 right, which can only be waived by a clear and unequivocal and knowing waiver, to say that you can be tried without having been informed of your date, and that in the absence of being of turning up, you can be tried in absence. Those two matters. So that's the residual question of if as your Lordship puts, this is just optional in the sense that we would at least have to say that Article 4A1 and 2 don't apply, otherwise it's mandatory return. So we have to knock that out, as it were, because otherwise it's mandatory return. And we say that they're not provided.
Okay.
But if and I accept that there's a body.
I mean, if they're knocked out, so it's not mandatory return, I'd have thought that's an end of conforming interpretation, right, so far as EU law is concerned, because the structure seems to be, as a matter of EU law, there is no discretion in the state but to send back to the requesting state if those conditions are satisfied.
Yes.
If they're not satisfied, it says the executing judicial authority may refuse to exercise the European arrest warrant where someone's been tried in their absence. So that just gives the member state, which is the requested state, an option how to proceed in that situation.
Yes.
So,
and then
the EU law doesn't tell you how they should proceed. It then falls into ordinary domestic law. It's a choice for the member state.
Well, and Article 6, of course.
Right. Well,
Yes. Well, my Lord, yes. Well, my Lord.
So is this right that you're saying there hasn't been a satisfaction of the condition in 4A1A little 2, so the mandatory element of return under EU law falls away? This is what you're saying, as I understand it. That opens up the authority, as a matter of EU law, for the executing judicial authority to refuse to execute the European arrest warrant. Whether they should do so is a matter of domestic law, which is Section 20, subsection 3 of the Extradition Act, and that has to be interpreted in accordance with Article 6 of the ECHR.
My Lord,
is that the way the argument works?
Yes, my Lord. Well, certainly we say that's the simplest route to address this, consistent with the authorities. Yes.
All right.
Sorry, my Lord, and therefore. No, my Lord. I'm extremely grateful. So what we say is, in relation to that, what we respectfully submit is that it's clearly a breach of Article 6 in circumstances such as this to put someone on trial where they have not been given the warning. And it's clearly a breach of Article 6 if they have left the country before they'd even been prosecuted, and yet their failure to give a forwarding address is said of itself to justify trial in absentia. But can I?
Is there any relevance to the idea that you have delegated to a lawyer appointed by the state to deal with these matters on your behalf? Is that a relevant factor at all?
We would submit not, because the delegation, you can't waive and you can't delegate in an effective way before you're aware of the fact you're being put on trial. If it's just a possible, as my lord, possible criminal proceedings, language of waiver is inappropriate. And my lords, I was going to take you to paragraph 17 of picture. Can I just, because I think I ought to, because it's an interpretation of section 23 at paragraph 17. I am satisfied the proper interpretation of section, this is page 872, requires a minimum that a trial process must have been initiated from which he has deliberately absented himself. Not enough he should be arrested in circumstances in which a trial is likely or inevitable. He will in circumstances undoubtedly be a fugitive. And so that's the point, that it must have started. And there are a series of cases which emphasize that point. And I can just show you that. In Podlas at 881, they're talking about a trial process, but they seem to be talking about it in the wider sense. So that's at paragraph 23. Thirdly, however, we accept that upon its...
I'm so sorry, I missed the page number.
Page 881, my lord. It says at paragraph 23, 881, thirdly, however, we accept that upon its correct construction, section 20, subsection 3, can only become relevant when, in accordance with the procedures of the relevant requesting state, a trial process has been initiated. Whether it has been initiated will be a question of fact. So we say that that is correct, but you can't have a wide definition of trial process. And for that, we go to Crety, where my Lord Burnett, this is at page 907 following, holds, at page 917, paragraphs 17 and 18, says you must seek a conforming interpretation. So that's paragraph 17 and 18. Over the page, my Lord cites Bicioch with apparent approval, and then cites Bletter, and you see at page 21, sorry, paragraph 21, 919, at C, what's cited is the focus is on a specific event at which the respondent could expect to be present. So a specific event. And then...
So where do we see that in paragraph?
My Lord, do you see between C and D on page 919?
Yes.
The focus is on a specific event.
Thank you very much.
My Lord, then if we go over there, from there, my Lord Burnett sets out the framework decision at paragraph 23, and 25, exception A enables the judicial to state in the ADW that the requested person was summoned in person and thereby informed. Alternatively, it may state he received the information by some other means. And then at paragraph 27, in my view, the natural meaning of scheduled date and place of the trial, which resulted in the decision, and scheduled date and place of that trial suggests that it is referring to an event which resulted in the person's conviction and sentence rather than the broad concept of a trial process. Indeed, it's not possible to notify a scheduled date and place for a legal process. So certainly it's stating that if one's looking at the terms of Article 4, 1A1 and 1A1, we're talking about being informed of the date of an actual trial, not some overall process. Now, it's quite right that then my Lord goes on to say that, to address the argument that there's got to be actual knowledge of the scheduled date. And then my Lord Burnett, paragraph 29, to my mind, these submissions are not consistent with recitals 1 and 8. And then recital 8 is set out where it says, under this framework, the person's awareness of the trial should be ensured by each member state in accordance with its national law. By each member state in accordance with the national law, being understood that this must comply with the requirements of the Convention, so that Article 6 obviously applies. In accordance with the law, case law of the European Court of Human Rights, when considering whether the way in which the information is provided is sufficient to ensure the person's awareness of the trial, particular attention could, where appropriate, also be paid to the diligence exercised by the person concerned. So that's citing that passage. And then recital 7 provides a narrative form exactly the same description, which emerges in paragraph 1A of Article 4A. These two recitals suggest that the phrase summoned in person, thereby informed, should be interpreted in accordance with the jurisprudence of the Strasbourg Court, when it was considered cases where a trial proceeded in the absence, who may not have been aware of the date of the trial, but was himself responsible for a state of ignorance. Furthermore, the structure of 1A1 itself suggests a contrast between the first alternative and the second. Now, and then it goes on to consider the question of Article 6. Can I try then to put how? I think paragraph 32 I should set out. However, in the context of a request to surrender a convicted person, the requesting judicial authorities expect to convey the relevant information in the EAW itself. If the information meets the requirements of Article 4A, that would provide the evidence upon which the executing judicial authority would act. And then it sets out that at paragraph 33, the United Kingdom was one of the co-sponsors of the 2009 framework decision. And then one sees that my Lord sets out paragraph 34, in my judgment, when read in the light of Article 4A, Section 20 of the 2003 Act, by applying a Bertino conforming interpretation, should be interpreted as follows. Trial, in Section 23, must be read as meaning trial which resulted in the decision in conformity with Article 4A1. That suggests an event. And then an accused must be taken to be deliberately absent from mistrial if he was summoned as envisaged by Article 4A1A in a manner which, even though he may have been unaware of the scheduled date and place, does not violate Article 6. We do put a bit of a question mark over that, but what I think one comes to is, as my Lord Sales put to myself, if 4A1A1 or 2, and 2 are satisfied, then the person must go back. Even if they're not satisfied because it's optional, there is a body of authority which says, even when they're not satisfied, you can then look at Article 6.
Yes, but is 34.2 saying any more than that?
Well,
you say you're not satisfied with it?
Yes. Yes, well...
If you accept that in the context where 4A1, A1 and 2 are not met, there may be an option on the court of the requested state to extradite the individual, so long as there is compliance with Article 6, then there is nothing wrong with 2.
Well, if he's been summoned as envisaged in a manner which, even though he's maybe not aware of the schedule, yes, so he's got to have been summoned. So there's, to the extent that my Lord is saying that there must be notice that there is to be a trial, but you may be unaware of the particular date, then we would certainly accept that that could be correct. I
mean, I rather understood the point being made by my Lord Burnett in Cretu in relation to the conforming interpretation, is that when you're looking to see whether the preconditions in Article 4A1, A1 and 2 have been met, because if they have been met, then it becomes mandatory to send back as a matter of EU law. You find a conforming interpretation of what is meant by the condition in subparagraph 2, in fact in both of them, but particularly in subparagraph 2. So you need to know, as a matter of EU law, whether the mandatory obligation to send back has been triggered, and for that you need a conforming interpretation of our Act in line with subparagraph little 2 of Article 4A. So you ask that question first, because if the answer is that these conditions have been fulfilled, then an obligation under EU law is triggered, and you have to send back.
Yes. Well,
it's only if you get through showing that either one of those conditions has not been satisfied, that you're free of obligation under EU law, so far as I can see, but then you're into questions of proper interpretation of our domestic legislation in the light of also Article 6 of the ECHR. Yes,
my Lord, I accept that must be right. And then therefore we say, what we say is, one, the mandatory requirements are not met in this case. Clearly he wasn't informed of the specified date, nor was he informed of the fact that he might be tried in his absence. And because EU law requires an unequivocal and knowing waiver, and that must be, as it were, after the prosecution process has been commenced, in this case there was no, it would be inconsistent with Article 6 to extradite, and inconsistent with the requirements of Section 20, subsection 3. So that's how we put it. And my Lords, in order to deal with that, I think we need to look at
Before doing so, I'm attracted, I must admit, to Lord Sale's analysis. But it might be said that if there is a discretion under EU law, under Article 4A, and that to maintain consistency across all the member states, that discretion should be exercised in the same way. So if Roman 1 and Roman 2 are not met, so there's no obligation to return, there's a discretion to return. The question that I raise is that subject to EU law or is that subject to domestic law? Certainly, if you look at the domestic law, Section 20, subsection 3 refers to trial, absent from his trial.
Yes.
And so the word trial would still have a conforming interpretation in Section 20, subsection 3. So I'll be grateful for your assistance.
Well, my Lord, we say we are free, sorry, the UK is free, if the mandatory conditions for return are not met, to decide whether the person would be deliberately absent from the trial, given the strong meaning of the word deliberate, in which we've and that if one looks at the Article 6 case law, which the cases do say you can go on to consider, it would be inconsistent with Article 6 to say that someone had waived their right to be present at trial by way of conduct before they'd even been charged or prosecuted. I mean, that's the point that in the issue.
Maybe a distinction without a difference. All the various domestic laws of all the member states have to comply with Article 6, and so therefore Article 6 is the test.
My Lord, I think if we look at Dworshevsky, which is at
just to tease that, in a sense, you rely on Article 6 twice, or at two stages of the analysis. I mean, the first is in producing a conforming interpretation of our legislation. One looks at Article 4A, little subparagraph little 2, and as I understand it, you say, in addressing what is meant there, since the EU law instrument is itself to be read conformably with Article 6 of the ECHR, you have regard to what Article 6 of the ECHR would require in order to see what EU law requires.
Yes.
And if you're right about that, and that means that subparagraph 2 has not been satisfied, so that one's outside the mandatory obligation under EU law and then into domestic law, you're relying on Article 6 again to say that it wouldn't be permissible under domestic law.
My lord, yes, and so we do say the same requirements that you should have been informed of the date and place of trial, subject to our one exception where you have deliberately sought to evade notice of that, having been given notice of the fact you're on trial, that you're going to be prosecuted. Subject to that. That is what Article 6 requires, and Article 6 also requires that you be informed that if you don't turn up, you may be tried in absentia. So what really, if one looks at the cases, I think I should take the court now to Dworshevsky, because that in our respectful submission may make the point. In Dworshevsky, which is at tab 64, this is often relied on for you.
The page, Mr. Fitzgerald.
Yes, Dworshevsky is at page 1728 and onwards is the key bit. In Dworshevsky, if one goes to page 1728, starting from paragraph 46, as regards the conditions set out in the second part of that provision, they are designed to achieve the same high level of protection of the person summoned by ensuring that he has the information relating to the date and place of his trial. Regard had in particular the wording of 4A1 of framework decision, which states that it must be unequivocally established that the person concerned was aware of the scheduled trial. The fact that the summons was handed over to a third party who undertook to pass it on to the person, whether or not that third party belonged to the household, cannot in itself satisfy those requirements. Then, admittedly, as the Commission has observed, it cannot in principle be precluded that handing a summons over to a third party satisfies the requirements. In order to achieve the objective referred to in that provision, however, it must be unequivocally established that that third party actually passed the summons on to the person concerned. Paragraph 49. In that regard, it is for the issuing judicial authority to indicate in the European arrest warrant the evidence on the basis of which it found that the person concerned actually received official information relating to the date and place of his trial. When the executing judicial authority ensures that the conditions set out in Article 4A1A of the framework decision are satisfied, it may also rely on other evidence, including circumstances of which it became aware when hearing the person concerned. Furthermore, as the scenarios described in 4A1A1, the framework decision were conceived as exceptions to an optional ground for non-recognition, the executing judicial authority may in any event, even after having found that they did not cover the situation at issue, take into account other circumstances that enable it to be assured that the surrender of the person concerned does not mean a breach of his rights of defence. In the context of such an assessment, the optional ground for non-recognition, this seems to be Article 4A, because that's, they just said, is the optional ground for non-recognition. The executing or judicial may thus have regard to the conduct of the person concerned. It is at this stage of the surrender procedure that particular attention might be paid to any manifest lack of diligence on the part of the person concerned, notably when it transpires that he sought to avoid the service of the information addressed to him. My Lord, can I just pause for one moment there? We place great emphasis on the words sought to avoid service. We say there has to be, if whatever this test is, is to be complied, it's got to be a finding that you were seeking to avoid service of the information addressed to him. If you ask yourself, well, what is the information that you're seeking to avoid service of? The information is the information referred to in paragraph 49, back at paragraph, official information relating to the date and place of his trial. So if you deliberately seek to evade service of the official information about your date and place of trial, it would appear that that could be a ground for saying, well, Article 6 is not violated, so you can be returned. And it may also be a ground for saying that Article 4A1A1 is not violated. But the 2 points we make are, firstly, it's got to be sought to avoid, i.e. intentionally seeking to evade information about your scheduled date of trial. And that obviously presumes that a trial is in prospect, not that you've done something years before. But secondly, it doesn't appear to justify dispensing with being told that if you don't appear, you will be tried in absentia. And that was the point that my learned friend Mr. Hall was making to Mr. Justice Swift, was that manifest lack of diligence may apply to 4A1A1, but does not apply to dispense with 4A1A2. But more broadly, if we're looking at Article 6, our respectful submission is there has to be, in being, a clear and inevitable prospect of a trial. And there has to be a seeking to avoid service of information about the scheduled date of trial. It's not enough to say, well, you breached an obligation to keep them informed. As a result of that, when they later decided to prosecute, it became more difficult for them to do so. And as a result of that, there is a failure on your part that justifies saying you were absent, you were deliberately absent. And that's both as a matter of domestic law. Deliberate absence are strong words which have been interpreted deliberate as being meaning more than recklessness. That's as a matter of interpretation of Section 20, subsection 3 under common law principles. But in any event, Article 6 would, in our respectful submission, only be violated if you knew that there was a prospect of a trial because you've been told you're being prosecuted, you are being prosecuted, and then you deliberately sought to avoid service of the information, the information about your scheduled date and trial. And, my lords, that's the point that we make, that the English law, or one strand of English law, made the wrong turning in the case called Zagreen, which we've analysed at 4.17 of the case at page 76, where the test which was actually followed by Mr. Justice Swift was adopted. However, the decision in Zagreen permitted the waters to become muddied, and having cited Dvorshevsky, the divisional court held that a requested person will be taken to have deliberately absented himself from trial where the fault was his own conduct in leading him to be unaware of the date and time of his trial. My lords, that's tab 32 at paragraph 81, page 951. So if we go to there, that's the passage which is relied on in this by Mr. Justice Swift, and we say wrongly so, that if you can't just simply say you breached an obligation as a result of which it became more difficult to get hold of you, therefore you've waived your right to be at trial. And that's where Zagreen, in our respectful submission, goes wrong. Zagreen is at page 961.
Sorry, 961 or 9?
No, yes, page 961, my lord, yes. Oh, I'm so sorry, that's Lakatos, I'm so sorry. Zagreen itself, you're quite right, my lord. Zagreen itself, in the relevant passage, is at page 950, analysis. So at page 950, paragraph 77, our reading of the decision of the Luxembourg Court in Dvorzhevsky is that it does not alter the principles enunciated in Cretu. The overall objective of 4A1 of the framework decision is to ensure the right to a fair trial by persons summoned to appear before a criminal court by requiring that he be informed in such a way as to allow him to organise his defence effectively. The list in 4A1 is designed to that end, so that if one or more of the conditions set out there are satisfied, an executing authority must extradite. However, 4A1A1 does not constitute an exhaustive list of how the end is to be achieved, since the conditions set out in that provision are satisfied if the person concerned was actually given official information of the date and place fixed for his trial by other means. The key question is whether surrender would lead to a breach of the extraditee's fair trial rights. That's the Article 6 question. And then at 951, paragraph 79, in Dvorzhevsky, the reference from the Dutch court was concerned with a specific case of the summons being handed over to a third party. The court held that 4A1A1 is not necessarily satisfied in that type of case. Essentially, the court concluded that because that method of service does not allow it to be unequivocally established, that the person concerned actually received notification of the trial. The court held that in such a case, the issuing judicial authority must unequivocally establish that that third party actually passed the summons. Notwithstanding the specific result in Dvorzhevsky, it is clear to us that even if none of the exceptions in the list of Article 4A1 apply, an executing judicial authority may take into account other circumstances that enable it to be assured that the surrender of the person concerned will not mean a breach of his fair trial rights. So that's the, as it were, you're back in Article 6 and domestic law. And then they say, moreover, the CJU was also clear the executing judicial authority can have regard to the conduct of the person concerned, what the court described in paragraph 51 as a manifest lack of diligence on his part, notably where it transpires that he sought to avoid service of the information the court sent. Thus, the approach in Cretu in interpreting Section 20 remains good. The requested person will be taken to have deliberately absented himself from his trial, where the fault was his own conduct in leading him to be unaware of the date and time of his trial. Well, with great respect, that's not that formulation was not what was decided in Cretu by my lord, and it cannot be right that any fault by his own conduct, which causally leads him at some stage to be unaware of the date and time of his trial, justifies saying he's deliberately absented himself from trial. So we say that that was a wrong turning, because what it suggests is all you, and that's really what Mr. Justice Swift found in this case, all you need is a breach of some duty of notification, such as there was here, and you're then taken to have deliberately absented yourself from trial. Well, the fault was his own conduct in leading him, i.e. causally leading him to be unaware of the date and time of trial. What's left out is that he's got to be someone who's on notice that he's going to be tried and who is, in the words expressly used in Dvorzhevsky, seeking to avoid service of the information being about his scheduled date of time, date of trial. And Mr. Justice Collins immediately raised a warning signal in the next case of Lakatos at page 9.
Just before you go there, you're accepting, I mean, you phrase it as the alternative case, but you've either expressed it as an alternative case or as an exception to your main case.
Yes, my lord, yes.
That somebody who knows that they're being prosecuted and then deliberately seeks to avoid intimation of the trial would be effectively caught. Why should it make a difference that you know that you're going to be prosecuted, as opposed to it's blatantly obvious that you are going to be prosecuted?
Well, my lord, because what we say is you can't waive the right until the right exists. Everything in Article 6 starts with you being charged, the rights of a person who's charged, 6.3. So what we respectfully submit is we're now talking about Article 6. Have you knowingly...
So let's assume a position where somebody believes that they are highly likely to be charged, and what they do is, to avoid that, they contradict the obligation to inform the police of the authorities and they disappear. Yeah? It then happens that they are charged. Why should that person not be brought within the arrest warrant?
Simply, my lord, because the Article 6 right starts when you're charged. And
well, you say that. Yes. I mean, that's our question to decide.
Yes, well, sorry, my lord, that's our respectful submission.
Yeah. That it can only start when you're charged, even in a situation where the person has been charged, might be a week later, for example. So they're investigated, they're told what the position is that they're investigating, the person decides, I'm clearing out, and then a week later they are actually charged. You would still say the arrest warrant.
My lord, I would, but I would say that he's not deliberately absent within the meaning of Section 20, subsection 3. But my lord, obviously, I know your lordship knows.
Well, we satisfy the requirement that he has deliberately left in order to evade information about what he thinks is a very likely charge.
Yes, my lord. We say that the knowledge that you are being prosecuted is what triggers the waiver, because you've got to waive something you know about, you know that exists. But my lord, I know your lordship knows that we do say there's many other reasons in this particular case. Which
sure. I'm just putting a hypothetical.
No. I understand, my lord, but that is our.
I mean, presumably the person wouldn't escape justice under this scheme, because they could still be arrested under European arrest warrant.
Yes.
In order to face trial.
Yes.
It's just that the problems arise where they've been tried in their absence, and the question is whether they're to be arrested in order to execute a sentence against them.
Yes, my lord, and whether they have a right to a retrial. Yes, sorry. Yes. As my learned friend rightly points out, that's addressed in Mr. Justice Mitting's judgment in Bitchioch, the question of even if it's inevitable. Yes. So that's why we take our stand on that.
Oh, sorry, can you give us the reference?
That's a paragraph 70. That's paragraph 7. It's paragraph 7. Where's the bit about inevitable? He says it's paragraph. It's in Mr. Justice Mitting's judgment in Bitchioch.
Page 867 of the bundle takes us to a point in Bitchioch, but I was just asking for some assistance with paragraph dealing with this.
Yes, it's paragraph 17 at page 872. Oh, yes. Yes, it is not enough that he should be arrested in circumstances in which a trial is likely or even inevitable. He would undoubtedly in those circumstances be a fugitive. And then what happened was he made it difficult or impossible to serve him with the documents. If he had been entitled unequivocally to a right of retrial or to have his own case reheard, his extradition would have been ordered. It's only because it is for the time being, except the Romanian law does not give him that right, that I must allow this appeal. So he does deal with the inevitable position.
Thank you.
But, my Lord, it's right to say he's looking at it more from the point of view of the interpretation of Article 41A, but we say the same applies under Article 6. My Lords, just briefly, we have dealt with this point under the heading ground free, the High Court's page 88 onwards of the case. And this is about at 9.2 at page 88. It is respectfully submitted that Mr. Justice Swift erred at paragraphs 25 and 33, as before it is permissible to infer the appellant had waived his right to attend trial, he needed to have been charged or otherwise have known that he was going to be brought to trial. And then we set out the various authorities we rely on. Obviously, Bitchioch is one of those. Jones in the United Kingdom at 9.4. And then at 9.5, a waiver of the principle in Sigbatullin, waiver of the right to appear, it must be a knowing, voluntary and intelligent act done with sufficient awareness of the relevant circumstances. So you've got to know that you are being prosecuted. We make the point that at 6.3a is expressly based on the determination of a criminal charge. So for a person to waive their right to attend trial, the ECHR requires a person has been formally informed of the charge, and we rely on the case of Sadovich, which is at tab 49. It was agreed the applicant had not received any official information about the charges or the date of his trial. Italy argued he sought to evade justice. The Grand Chamber held that an accused may waive their right to attend trial where the evidence unequivocally shows that he is aware of the proceedings against him and of the charges he faces. They reiterated the importance of a person being informed of a prosecution brought against him, and they made the point that it had not been shown that the appellant had sufficient knowledge of the prosecution and of the charges against him. T in Italy is...
Could you just give the paragraph number again? I'm sorry, Mr. Fitzgerald.
Of our case?
No, in Sadovich.
Sadovich, 99, my Lord.
Thank you.
May waive their right, where the paragraph 99 of Sadovich, yes, ma'am. And then the same effect, at paragraph 101 of Sadovich. It had not been shown the applicant had sufficient knowledge. And T in Italy, again, vague and informal knowledge cannot suffice. And that was quite a dramatic case because he was accused by his daughter of rape, and he was indirectly aware, but they made the point, and this is at paragraph 28, we've cited at page 90, the court finds that the applicant has learned indirectly the criminal had been instituted against him. To inform someone of a prosecution brought against him is, however, a legal act of such importance that it must be carried out in accordance with procedural and substantive requirements capable of guaranteeing the effective exercise of the accused's rights, as is moreover clear from Article 6, paragraph 3a. So those are the points. So if applying those principles to the facts of this case, we say there was no knowing, voluntary and intelligent, as it were, informed waiver. The 23rd of July document, this is at page 90, 9.11, it says investigations are being conducted. It's not a charge, not a formal accusation. It was not the beginning of a trial process, let alone a prosecution process. And in fact, the decision to prosecute was not taken until the 8th of June 2017. I know the court has that point. And then in this regard, we say it's very different from the Zeal case in Poland, which is tab 38. And where it was said, on any view, Mr. Zeal knew he was to be tried. So, my Lords, then in answer to the question that the board itself posed, is the test subjective, objective, or mixed, as it were, or does it require actual knowledge? I think was the actual question that the court formulated to us. We say, essentially, it's subjective. It's about actual foresight of a trial and actual knowledge of the fact that if you don't turn up, you'll be tried in absence. But we do accept that there is one further point, which is this, that if the person knows he's being put on trial but deliberately seeks to evade knowledge, then he's consciously and deliberately seeking to evade service of the information. But vague language of "you haven't shown enough diligence in keeping in touch" is, in our respectful submission, not enough. And saying, well, if you had kept in touch, as you should have in your general duty to obey the prosecutor's directive, the police officer's directive, but as a result of not doing that, we weren't able to contact you, that's not a waiver of the right to trial in presence. It's not deliberate within the meaning of Section 20, subsection 3.
Mrs. Fitzgerald, you are now eating into your reply time.
Okay, well, my lord, you then have our final point about Mr. Justice Swift drew an inference, and we say that he should only have drawn that inference if it was the only inference that could be drawn in those circumstances, and we've set that out at ground 4 at pages 97 onwards, my lord. Yes. So, my lord, so those are our submissions. I'm sorry if we were derailed at the start by my, but my lord, you essentially, I suppose it really is ground 3 is crucial, because really that addresses the question of Article 6. It addresses the question of, would it be a violation of Article 6 to deny him a trial in his presence in these circumstances? And we say yes, because there is no knowing and unequivocal waiver at a time when he's on notice that he is actually being prosecuted and is actually facing a trial. My lord, those then are our submissions.
Mr. Fitzgerald, thank you very much. Mr. Malcolm.
Well, thank you. My lords, you have our case, and it wasn't my intention to repeat it or even to go through that. I would rather take, if I may, a broader view, which is to answer what I certainly understood the point of law to be, which is whether on the facts as found there has been deliberate absence. Now, Lord Sales summarised the point of law at an earlier stage today. A great deal, my first point has already been taken by your lordships, that a great deal of emphasis in the documents provided has been on undermining the evidential foundation. But I think we're beyond that point. The point of general public importance is, in my submission, where on the spectrum of total ignorance, on the one hand, to the fully fledged compliance with Article 4A1 and 2, that is, personal service of a summons, informing a requested person of the date and time and place of trial, and of the consequences of his not attending, deliberate absence can cut in. So there's a vast spectrum there, and the cases cover the entire spectrum. On the furthest right-hand end, if I can put it that way, the Article 4A1A, no inquiry is permitted and extradition is automatic. The cases at the other end of the spectrum, and you've heard some of them mentioned already this morning, and it's important that it is understood, for instance, Sedgwick, Sibgotulin, T, those were cases where the requested person had left the jurisdiction before they had any inkling that they were under investigation before they had been accused, before they had been in contact with police. And in those circumstances, it's not surprising that an in absentia trial that takes place without their knowledge could not be enforced. And the whole purpose, if I may, and I'll come back to a purposive construction of Section 20, but the entire purpose is to protect, in those rare cases where somebody has absolutely no idea that they have been accused, tried, convicted and sentenced in a foreign state, and they're returned to face a sentence, sometimes of years, without having had any opportunity of disputing the underlying facts. And that's what, in turn, gives rise to questions of deliberate absence and questions of a right to a retrial under Section 25. So, in my submission, there is a vast spectrum of knowledge, and the question for this court, and the question of general public importance, is where on that spectrum you can be taken to have deliberately absented yourself. And may I make a number of preliminary points? The context in an extradition court is not that the judges at Westminster are making a decision about when a trial in absence is fair or appropriate. As was indeed pointed out by my Lord Burnett in Cretu, and we'll obviously come back to that decision, that whether a trial in absence is fair is a lengthy and fact-specific inquiry. That was, I think, the words used at paragraph 31 in Cretu. And an extradition judge is required to assume that the inquiry has been carried out in compliance with ECHR requirements. And if you want the reference for that, it is EDL, which is at tab 75, page 1875.
Page?
1875. At paragraph 30, which is in turn at page 1880. It must be assumed, save in exceptional circumstances, that there has been compliance, thank you, there's been compliance with fundamental rights. The principle of mutual trust requires, particularly as regards the area of freedom, security and justice, each of those states, save in exceptional circumstances, to consider all the other member states to be complying with EU law and particularly with fundamental rights recognised by EU law. Thank you very much. So the context is important. The context is also one of extradition, which under the European system is in...
So just on that.
Yes.
I mean, Article 4A1 seems to be a departure from that general principle of trust because it sets down very precise criteria that need to be satisfied before it becomes mandatory under EU law to send someone back.
Well, Article 4A1 was brought in as an attempt to bolster mutual trust and recognition. What had happened before, when the framework decision of 2002 was originally brought in, it contained Article 5.1, which allowed an executing state to ask for and then consider a guarantee as to retrial in cases of in absentia conviction. And the wording used there was a guarantee deemed adequate. And what that meant was that the executing state had to go through a process of deciding for itself, in each case, A, whether it had a guarantee, and B, whether it deemed it adequate. That, and it's in the recitals, in recital 2 of Framework Decision 2009, the effect of that was to cause diversity, a lack of certainty as to whether somebody would be returned, and diverging bases for what was adequate. So 4A1A came in, or 4A came in, setting out 4 distinct conditions under which you could not refuse. But it still left open the rest if there were ambiguity or confusion, or, as in this case, if no relevant box was ticked, it left open the possibility of an optional refusal to return.
Right. But I was just questioning the relevance of paragraph 30 of EDL that you were just showing us. So I wouldn't have thought that if the preconditions in Article 4A1 are not satisfied, that it then goes directly into the principle of mutual trust and you have to send the person anyway.
No, I'm sorry, I've misstated it if I put it that high. It's not, of course.
This seems to be stating what in EU law terms is the required minimum satisfaction of fundamental rights.
It's a little more than that, without being a requirement automatically to return. My point is only that this is within the context of the fundamental underpinning of the European arrest warrant, that it is, you start from a position that it's assumed that defence rights have been respected. And EDL suggests in EU law that that assumption applies, save in exceptional circumstances. Now, it may not always, we all know it is not always the case, and that is not a full answer, but that's your starting point. That was the only contextual point that I was trying to make. And as I was going on to say, the other point is that the context is a swift and speedy return, which argues against lengthy evidential inquiries in the executing state, again deprecated in the case of Cretu at paragraph 35, also at 42, and also, as I've just said, being the very reason for the deletion of Article 5.1 from the framework decision. It's again just a comment made, but LU and PH, I think you haven't yet been taken to that. Tab 74, page 1858. And I'm merely going to give you the reference for the time being, if I may. At paragraph 56, which is at 1868, the comment being that you facilitate mutual trust by avoiding giving the executing state a general function of review of all procedural decisions in the issuing member state, which would include a decision to proceed to trial in absentia.
Which box in the European arrest warrant ought to have been ticked, or should none of them have been ticked?
The answer, I think, is the retrial box, probably.
Yes.
Right.
In terms that that was, at one stage, an issue. It is very clear that, there is an argument about B, mandated by the lawyer, but that begs the question, mandated a lawyer, but that begs the question about whether he had been informed of the scheduled trial. Because, of course, he was informed, as was his mandated lawyer, but only to the address that he had notified the authorities. So
Are you advancing the case that Article 4.1a, Roman numeral 1, has now been satisfied? And if so, then why isn't the relevant box ticked? Or are you relying upon a discretion, accepting that 1 and 2 have not been satisfied, but still there's sufficient to return them?
I can't answer why no box was ticked, except to say that none of us would be here if it had been. But clearly he wasn't summoned in person because he didn't make himself available, nor did he by other means actually receive official information. So 4A1A1, it is the most confusingly numbered article, does not, in my submission, apply. Because that is, if you can prove actual service in person or by other means. Query, as I've just said, whether 4A1B applies, because he had given a mandate to a legal counsellor, but on the facts I accept that may be questioned, and in any event there is the question mark over being aware of the scheduled trial.
A mandate would be instructive, presumably.
Well, again, there's a question over that. He ticked, to take up my Lord Stephen's point, Lord Borough's point, he said that he wished to be represented by the court-appointed lawyer. Now, it's unclear whether he gave any instructions to that lawyer, but in cross-examination, he said nothing was received by the appointed lawyer, which does tend to suggest that he was in touch with the lawyer.
It doesn't tell us when.
Exactly, it doesn't tell us when, I agree. He also said that he'd instructed his own lawyer and paid him, but he doesn't say what discussions there were between them or when, and indeed, part of the difficulty of this is it would probably have been forbidden to have asked that question, given privilege. So, my default point is if you were going to tick anything on here, the safest course would be the retrial, but the fact is that nothing was ticked, and that is not the end of the story. It falls into the category of optional non-return, depending upon the findings of fact. Since we're dealing with Article 4A, may I...
Optional non-return depends in turn upon Article 6. And,
Yes. And the preservation, the proper preservation of his rights. It also depends on the various derogations contained within the recital in 4A, where he has sought to or put himself intentionally in a position where he cannot receive information, any information. But I'll come back to that. May I, since we're on 4A, just deal with the point in order, I think, to underline it. There was a moment where I thought my learned friend was suggesting that the only options were 4A, and there was no residual optional non-return and discretionary non-return. I think he's resiled from that, not least because he relied upon and quoted from Dworzewski, which makes it very clear. But before you even get to the case law, in my submission, the wording of 4A is very clear. What it says is there is an optional, what it says is there is a mandatory requirement to return in the situation set out there, and there is, underlying that, an optional ground of non-return which deals with everything else, which, as you rightly said, requires confidence that the Article 6 rights have been complied with. I take that from the wording of the article. I take it from recital 4. I take it from the express statement in recital 15 that this is an optional bar. I take it from Cretu at paragraph 31, and specifically from the case of TR, which you'll find at tab 70, which is at page 1810, at paragraphs 51 and 52, which in turn are at page 1820.
I trouble you again for the Cretu reference. I just didn't know.
Cretu was is tab 31, which starts at page 907.
You gave us a paragraph, and I'm so sorry I didn't know.
I think I wrongly gave you 31 as the paragraph. That is the tab number at 907. And it's less explicit, it's right to say, in Cretu than it is in TR. But it's very clear that, well, perhaps I shouldn't be putting words into anyone's mouth, but it appears from reading it that there was no suggestion that it's these four or bust.
Yes, well, I mean, the words, the opening words of Article 4A, the executing judicial authority may also refuse to execute ... unless.
Exactly, which is what I've described in the case as the negative wording,
yes.
Whether that's sufficiently clear or not, but that's where you start. The recital 15 says in terms it's optional, and TR, which I was just going to take you to, says at paragraph 51, if the executing judicial authority were to consider that the conditions set out in Article 4A1A or B, which preclude the possibility of refusing to execute the EAW, are not satisfied, as Article 4A provides for a case of optional non-execution, that court may, in any event, take into account other circumstances that enable it to satisfy itself that the surrender of the person does not entail a breach of his defence rights. And then they go on at paragraph 52. In the context of that assessment, the executing judicial authority may thus have regard to the conduct of the person concerned. It's at this stage of the surrender procedure that particular attention might be paid inter alia to the fact the person concerned has sought to avoid service of the information addressed to him, or even has sought to avoid any contact with lawyers appointed by the Romanian courts. So, although, as I understand it, my learned friend is now agreeing with that proposition, it's important to have it in mind because others have, and I don't mean other barristers, there are cases in which the use of 4A has been quoted perhaps as shorthand, but not understanding that that is the paradigm informational position against which you test the individual facts. But it can be very misleading. And may I just give you the one example of Bikiok, which is going back to tab, I'm afraid, 27. It's at page 865, and it's at paragraph 14 of that judgment, which is in term at 871. And you may not be surprised to hear that we have a number of things to say, perhaps, about Bikiok, which is a single-judge decision. But at paragraph 14, Mr. Justice Mitting says, Framework decision of 2009 accordingly makes it clear that as a precondition of a requirement for the executing judicial authority to extradite, the person must be notified in due time of the scheduled time and place and told if he doesn't attend, the decision may be handed down. In my submission, that is putting it too high.
Yes, I raised a question based on the reference to
yes.
Paragraph 14. I mean, paragraph 14, the opening words of it don't seem to recognise the negative wording of Article 4A?
Yes.
Now, just coming back to the paragraphs you showed us in TR.
Yes.
Again, one needs to be careful not to take subclauses out of context.
Yes.
In paragraph 51, where the court is saying, even if the boxes aren't ticked, there's a discretion. When it talks of breach of his rights of defence, is that simply to be taken as a clear reference to what is in fact Article 6?
In my submission, yes.
So
Yes.
is the court saying more than if the extraditing court is, leaving aside the box-ticking exercise, satisfied that Article 6 has not been breached or will not be breached because there could be a retrial, then it can still return?
Yes, exactly. As I read it, all they are saying is Article 4A doesn't set out the whole picture. Of course, that's not the end of the story. You then have to go on to ensure that somebody had waived their rights,
Yes.
Unequivocally, which
As understood by the Strasbourg court.
Exactly, yes. And I accept, and I have no issue with my learned friend, that deliberate absence means what it says it means, that it is deliberate. It involves some decision which means he must have known that there was at the very least a danger, which is why Sibkatulin, Sedjovic, T, they don't fall into this category. And he must have done something deliberate to avoid service on him of documents. I don't suggest that this is something one can do negligently or recklessly or still less unknowingly. But of course, the degree of what you have to know is what is in issue. And the facts that establish what you know is in this particular case in issue.
Is there any Strasbourg authority that suggests that knowing that there's a danger you might be prosecuted is sufficient?
Well, the Strasbourg authorities are by definition all looking at whether there has in the past been a breach of Article 6.
Yes.
So far as I'm aware, the answer to your Lordship's question is no, because it would never come before the Strasbourg court. But I will turn to my very well-informed junior and be corrected over the short adjournment if I'm wrong about that. But may I, just before the short adjournment, deal with the final paragraph of Bichiok, because it has some relevance to this. Or I'd say the final full paragraph, which is on the following page, paragraph 17. You've been taken, which is a partial answer at least, your Lordship's question, to the beginning of that paragraph. I am satisfied that the proper interpretation requires, at a minimum, the trial process must have been initiated. It is not enough that he should be arrested in circumstances in which a trial is likely or even inevitable. But he then goes on to say, as it happens, the structure within which cases of this kind should be dealt with within the member states is, in my judgment, that set out in the 2009 framework. As it happens, our law is capable of being aligned with it, was for several years thought to be so aligned. It should revert to that position. So what Mr. Justice Mitting is saying, in effect, is to accept that he has gone out on a limb, or at least that he is not in consort with other judges, when he makes the comment that somebody has to be arrested in circumstances in which trial is likely or even inevitable. And he himself had in fact quoted from Mr. Justice Ousley at paragraph 11, 2 pages before, 869 of the same judgment, what he calls a more generous, as far as the requesting authorities are concerned, approach to, it says section 23, but it clearly means section 20, subsection 3, was followed by Mr. Justice Ousley and Zwolak, By then, the 2009 framework decision had been enforced for over 4 years, although it doesn't appear to have been cited, no reference made. But he accepted a concession made by counsel, and he then sets it out. It is
Sorry, which paragraph's this?
It's paragraph 11, my Lord,
11, thank you.
page 869.
Thank you.
It's accepted by Mr. Williams, quite rightly, said Mr. Justice Ousley, that it is not necessary for an appellant to know there will be a court hearing or to believe that a court hearing is inevitable in order for him to take steps which warrant the conclusion he had deliberately absented himself from trial. It's sufficient if the appellant takes steps knowing there may be a trial and takes them deliberately to avoid the authorities alerting him to its date and place. I draw that to your attention only to say that it's in the light of decisions such as that that Mr. Justice Mitting was attempting to pull back the law and knew that in doing so he was out of kilter. My Lords, would that be an appropriate moment?
Yes, indeed.
Thank you.
Thank you very much. The court will now adjourn.